Good afternoon. Thank you all so much for being here. This is the program we do each year where we talk about the United States Supreme Court, what it did last year, and what's on the docket for this year. We sure have a lot to talk about today. And we have wonderful panelists to discuss this. I'll quickly introduce them. I obviously could spend all of the time this afternoon just telling you their credentials, but let me briefly introduce them, then talk about how we're going to go about this. Immediately to my left is Easha Anand, a 2014 graduate of Berkeley Law. She's had a distinguished career. She clerked for Justice Sotomayor on the Supreme Court. She's now a visiting professor at the Supreme Court Clinic at Stanford Law School. She's counsel and appellate counsel at the MacArthur Justice Foundation. Next to her is my colleague, Amanda Tyler, professor. Yes. Professor Tyler is the Shannon Turner Professor of Law here. She teaches especially in the areas of federal courts and civil procedure, and among other things is co-author of the prestigious Hart and Wechsler Federal Courts Casebook. And next to her is my colleague, Professor Seth Davis. He's also had a very distinguished career. He teaches especially in the area of tort law and Indian law. He writes extensively on those topics and is co-author of a forthcoming federal courts casebook being published by Aspen. And with that, here's how we're going to go about it. Each of us is going to take a few minutes to give an overview, our thoughts of where the court is now and where it's likely to go in the future. Be followed by then each of us taking one case from last term and describing it and what it's likely to mean. Then each of us take a case for the coming term, which starts on Monday, the first Monday in October. And then we'll save about the last 15, 20 minutes for any questions you have about any of this. Easha, I'll start with you.
Thank you so much, Dean Chemerinsky, and thank you for inviting me to this event. I love this weekend. I love being a Berkeley alum. This is so energizing for me, so thanks so much for having me. So I want to talk with my kind of overview remarks of kind of two consequences of this sort of relatively newly constituted 6-3 court. So the first one is, this year, this past term, was the sort of low point for unanimous opinions. Only 29% of the opinions were unanimous compared to something like a 43% average over the past decade. And 30% of the opinions were decided 6-3 along purely party lines. Now, that may not sound so remarkable, right? Of course, there's sort of now that the court has become more partisan, of course, there are more cases that are decided along party lines, but it is a real break with kind of the tradition of the court, which is to say for every politically polarized, high salience case, there usually were 4 to 5 other cases that were sort of 9-0, 8-1, 7-2 opinions because the justices were sort of getting into the kind of nitty-gritty of law. And there are a lot of reasons for that, but one I want to kind of highlight here, which is to me the sort of one of the biggest differences between having a court that was 5-4 conservative to liberal and having a court that's 6-3 conservative to liberal, is that to grant certiorari in a case requires 4 votes, right? And so when you had 5 conservative justices and 4 liberals, some amount of the agenda could still be set by the liberal justices. So when I was clerking, there were every term, I think, a handful of cases where the person who was petitioning was a criminal defendant or a non-citizen facing removal. And, they weren't, if they were granted, they were going to be 9-0 or 8-1 opinions because the text of the statute was clear, but you needed 4 people to care enough to grant, right? And so I want to suggest to you that one consequence that hasn't gotten enough attention of this kind of partisan shift, the big difference between a 5-4 and a 6-3 court, or one of the big differences, is the kinds of cases the court is taking just look different because there are no longer sort of 4 votes for someone to grant unless they kind of pick up a conservative at the agenda setting stage. So that's the first consequence I want to focus on. The second I want to tee up is, in the past, it has been the case that the fact that the conservatives on the court didn't all think entirely alike was an asset rather than a liability for progressive advocates, right? So you could pick up, if you had 4 liberals in the court, You could pick up a fifth vote in a kind of institutionalist case because the Chief Justice sort of had some of those priors. You could pick up a fifth vote in a sort of, libertarian or due process-y case because Justice Gorsuch had those priors. And so it actually was you could pick up a fifth vote in a sort of quirky arbitration case or some Voting Rights Act cases because of Justice Thomas's idiosyncratic views. There was sort of a variety of ways to count to 5 and a bunch of different categories of cases where there might be a fifth vote to vote against type or vote against political party. So for a long time, that was an asset, right? You had a bunch of different kinds of cases that you could plausibly count to 5 on. Now that it's a 6-3 court, right? So now that for any liberal cause, the 3 liberals have to pick up 2 additional votes, the fact that each has sort of idiosyncratic views has become a liability rather than an asset, right? The Venn diagram of overlap between any 2 of the conservatives on the kinds of issues they'll break with party for is pretty tiny. So you see this. I know that Professor Davis is going to talk more about the Castro Huerta case, which is an important Indian law case, where the liberal justices, Justice Gorsuch voted with them, and they still lost, right? Because the fact of the matter is that the kinds of cases on which one of the conservatives is likely to part ways with their fellow travelers, there probably isn't a second willing to do it in that same subset of cases. So those are sort of 2 of the consequences. Obviously, there are many far more monumental consequences of the 6-3 court, but I think 2 that have been sort of undercovered are this sort of agenda setting and the kind of difficulties of counting to 5. Before I turn it over to, I think Professor Davis, I think you're maybe up next. Is that right? Yeah. Before I turn it over to Professor Davis, I just want to say one more thing that's not really about the court, but more about the people who are arguing in front of the court, the so-called Supreme Court bar. This past year, the percentage of women arguing at the Supreme Court went down slightly from previous years. 86 men and 32 women argued at the Supreme Court, and the number of attorneys of color was just 6. These are sort of paltry and sort of pathetic statistics, and I want to just sort of spell out one of the consequences of this for the kind of substantive work that the court does, right? So the Supreme Court bar, for folks who aren't sort of in that DC insider community, it is now the case more than ever that the person who handles a case at the United States Supreme Court is not always the person who handled it below. So there's a sort of whole network of folks, many of them who clerk for the Supreme Court themselves, who've cultivated sort of Supreme Court specialization, who tend to kind of come in and take over cases once they get to the Supreme Court stage. And that bar is remarkably homogenous, right? And I think that the statistics I'm describing in part reflect the kind of homogeneity of that bar. And one of the consequences of that I think we're seeing more and more is that the folks who are arguing at the court are generalists who know a lot about the Supreme Court rather than subject matter experts. And so I think you can sort of hear more and more in the tenor of the oral arguments that folks may not know, the sort of full sweep of consequences. You have people arguing criminal cases who have never represented a criminal defendant in a plea negotiation, for instance, and so don't know how some of these questions before the justice play out on the ground. So I just want to leave you with that sort of final thought as you're thinking about the Supreme Court. Also be thinking about who's presenting argument and who's presenting briefs to the court.
Seth?
I'll just very briefly identify 3 themes that I'd invite us to think about, both in relation to last term and going forward as we think about this upcoming term. One is around the question of legitimacy, and I think there's 2 questions here. One is, what's the standing of the court in public opinion? If polling is any guide, it's not great at the moment, but Chief Justice Roberts, for instance, recently said that's not how we should measure legitimacy of the court's opinions. Justice Kagan disagrees. Even if we take Chief Justice Roberts' view seriously, and that view is, let's take a look at the court's decisions and its interpretations of the Constitution, that does raise another sort of legitimacy question, is what do we think is legitimate decision-making from the court? And one issue that raises this is, what's the role of stare decisis and precedent in the court's decision-making going forward? I think a second theme is, in a significant sense, this looks more and more like the Kavanaugh court. Take, for instance, Kavanaugh's concurring opinion in Dobbs that purports to offer limits on the court's opinion in that case. For instance, he thinks that there's a constitutional right to travel from your home state to another state to obtain an abortion. And it seems like he'll play an important role in determining future questions like those as they arise. And then the third theme I'd highlight is one that my colleague, Professor Tyler, has written very powerfully about, which is the role of history in federal courts jurisprudence, or just jurisprudence more generally. I remember actually when I was just starting my career as an academic, attending a panel that you spoke on that topic, and then I think it was followed by a Notre Dame Law Review piece. But what is the role of history in the court's decision-making going forward? Bruin, the firearms case, tells us history matters a great deal. It gives us the test. Castro Huerta, the Indian law case I'll be talking about, tells us history doesn't matter. The original understanding doesn't matter. So what's the role of history moving forward in the court's decision-making? With that,
that was very nice. Thank you. I remember that because, just on that note, it was a panel that on which Justice Scalia spoke that I organized about the role of history in federal courts jurisprudence. And I wrote something after the fact that said history is messy. Surprise, surprise. And a great anecdote from that event was, I'd written something about the Calling Forth Act, and I said, Justice Scalia, are you aware that at the founding, the Second Congress passed a law that said George Washington had to ask a Supreme Court justice to certify that there is an emergency before he can call forth the militia? And that's in fact what happened when George Washington put down the Whiskey Rebellion. He asked Justice James Wilson to certify that circumstances were bad enough to justify that. And Justice Scalia said, "You're making that up, right?" And I said, no, no, that happened. But I want to open by actually stepping back and saying thank you. It's great to be here with all of you. I love this event. I love seeing the alums back in the room, especially former students. It's just a really special thing. I had the privilege, I have to say, I'm going to brag here a little bit. I had the great privilege yesterday of attending the ceremonial investiture of my very dear friend who I had the privilege of clerking on the Supreme Court with the same term, who is now Justice Jackson. And that was very special. Well, one of the fun, cool things that happened that day is I got to hang out a little bit with the second gentleman, Douglas Emhoff, as you do. And while I was talking with him, he said, it would really do me a favor if you would pass along my regards to my young, cool, and hip con law professor, Erwin Chemerinsky. So, sorry, Erwin, I decided to pass it along here. Doug says hi. So yesterday, I'm coming off of a real high from yesterday. I just thought it was a really great day for the court, a really great day for our country. But now, when I look back at last term, I'm not on a high. I'm really troubled by some of the things that we see unfolding with respect to the Supreme Court. So one thing that Seth touched on is the role of precedent. The court is really struggling, I think, with what to do with respect to stare decisis, and we're seeing, in my humble view, really an unprecedented lack of regard for stare decisis. And I say this not because of Dobbs, not because Dobbs overrules Roe and Casey. We all know that. I say this because of a lot of the cases, that are not making headlines, we see a lack of regard for stare decisis. So we're seeing it, one, in a lot of cases, and two, in a lot of places where it's sort of under the radar. So I'm thinking, for example, of a case in which the court has now called into question the validity of Miranda and started calling it a prophylactic rule again. Well, that went on in the wake of Miranda, and then during the term in which actually Justice Jackson and I clerked, the court heard a case called Dickerson purporting to put to rest that debate and saying, no, it's not prophylactic, it's constitutionally required. And in effect, the court reheard Miranda, and now we're being told, well, actually, maybe Dickerson is wrong. You're going to talk about Castro Huerta. I think that is enormously troubling from a stare decisis standpoint. All of a sudden, states have regulatory authorities over tribal lands. I mean, this is, wow, pretty extraordinary proposition. Kennedy, the prayer case on which Irwin's really an expert, they throw out the Lemon test. We see Gorsuch calling for the overruling of Brown versus Allen. I mean, there's a lot going on in that regard, and it's not just happening in Dobbs. It's happening in a lot of cases, and I think that is showing that the court is trying to go very far, very fast, and that has implications for legitimacy, and I do think that the court's legitimacy is something that they should be thinking about, because if the public doesn't buy into what the court is doing, doesn't believe that the court is operating in good faith, that has real serious ramifications for the rule of law in this country. The other thing that the court is doing that I think is really quite significant is the procedural norms and traditions that have governed for very long are really getting thrown out the window. And we see this nowhere else more than with respect to the so-called shadow docket. So the number of merits cases the court is deciding in the last 3 terms in particular are among the lowest it's really decided ever. We have terms with 53 merits decisions, 58 merits decisions. Just 20, 30 years ago, they were deciding 150. Maybe that's too many. People can debate that. 53 is pretty small. Those are the cases in which they're receiving full briefing and oral argument. But one of the reasons why that number is so low is because they're deciding so much on the shadow docket, on the emergency docket. And particularly during COVID, we saw them making really significant religion decisions with respect to free exercise and other First Amendment claims. We see them very active in the vaccine context, in the eviction moratoria context. So the court is making really big decisions, and they're really about the merits. A lot of the court members don't even bother discussing the standards for emergency relief, even though those cabin, in theory anyway, what the court is allowed to do on the emergency docket. A lot of the justices in these cases where there is not full briefing, there is almost never oral argument, and everything is on a very tight timeline. They're making really big-time merits decisions, and in some cases making new law, which is something else they're not supposed to be doing on the emergency docket. And they're also taking cases before judgment. They're allowing cases to leapfrog the circuit courts to come to them. That's not something the court has done in the past, really, other than very rarely. And yet, I think in the last 3 years, they decided something like 19 cases that came to them on cert before judgment, which is just an extraordinary number. So I think when you put together the combination of a court that is less caring, if you will, about stare decisis, along with a court that is really less wedded to traditional procedural norms, the combination shows that this is a court unlike one that we've seen in almost 100 years, and I think that should trouble us.
My colleagues have done a wonderful job in talking about the term. I think the one thing that I would emphasize is how dramatically the court changed the law this term. I can't think of another term as momentous as this in my career or my life. Maybe the only term I can think of that was historically analogous was October term 1936, because in 1937, the Supreme Court overruled 40 years of precedents that limited Congress power and the state power to adopt progressive laws safeguarding workers and consumers. And I think it's so important to have the sense that this wasn't a term of incremental change, but momentous, dramatic change. And it wasn't in minor areas of law. It was in areas of the law that are most divisive in our society, and for that matter, areas of the law that touch people in some of the most intimate, most important aspects of their lives. I think part of this is the rise of originalism on the Supreme Court, and it's something that's been touched on, but I think is important to bring to the surface. Originalism is, of course, the view that the meaning of a constitutional provision is fixed when it's adopted. It can be changed only by the amendment process. It's not that long ago that originalism was thought of as a fringe, dangerous theory. In 1987, Robert Bork was nominated for the Supreme Court. He had impeccable credentials. He had been a Yale law professor, Solicitor General of the United States. He was a judge on the D.C. Circuit. Yet he was rejected by the Senate by the largest margin of any nominee in history. And it was because of his originalist views. He had said and written that there should be no protection for women against discrimination under the Equal Protection Clause, because that wasn't the framers' intent of the 14th Amendment. He said there should be no protection for privacy autonomy, because that's not in the Constitution or part of the framers' intent. He said the First Amendment should protect only political speech, because that's all the framers intended. No safeguarding of speech for entertainment, let alone sexual speech. And 58 senators voted against him for this. Now we have 3 justices on the court who are self-avowed originalists, Justice Thomas, Gorsuch, and Barrett, and 3 other conservatives who often write their opinions in originalist terms or sign on to them. There's so many problems with this approach to constitutional law. Some of it is, Amanda said, history is messy. It's not as if there is an original understanding to be found. Think of what the court did this term. It said no abortion rights in the Constitution, the government in some circumstances is obligated to subsidize religious schools, that there's a First Amendment right of teachers to pray at school, at least in some circumstances, that there's aggressive protection of gun rights under the Second Amendment, there's enormous limits of administrative agencies. Unless you believe that the framers' intent and the current Republican platform are the same, you see exactly what the court's doing. They're reading their conservative values into the Constitution and pretending it's part of originalism. It's always possible to pick and choose from history to come up with the examples you want to support your conclusion. But history is often useless in deciding current issues. Take the case about the football coach. What did the framers think in 1791 about the right of a football coach at a public school to pray on the field? Just to ask the question shows how meaningless it is. Or there's a major case that's going to come, I think, to the Supreme Court this term that involves whether Texas and or Florida can adopt laws that prevent social media companies from engaging in content moderation. What did James Madison think about social media companies and content moderation? But if we're originalists, it leads to abhorrent results. Brown versus Board of Education can't be justified from an originalist perspective. The same Congress that ratified the 14th Amendment voted to segregate the District of Columbia public schools. Conservatives have admitted there's no evidence whatsoever that the framers of the 14th Amendment meant to outlaw segregation. Or take Loving versus Virginia. Almost every state, when the 14th Amendment was ratified, had laws prohibiting interracial marriage. California had such a law until 1948. In 1967, when Loving was decided, 16 states still had such laws. I could go on and on with examples of originalist abhorrent results. And of course, what's especially troubling is that the conservative justices don't follow originalism when it doesn't get to the results they want to come to. I mean, an easy example of this that we'll talk about is the affirmative action cases this term. Strong evidence that the drafters of the 14th Amendment believed in what today we'd call affirmative action. They adopted race-conscious programs like the Freedmen's Bureau. But when Justice Scalia and Thomas dissented in affirmative action cases, they never mentioned that history. And of course, to me, what's so frightening is when you have a conservative court committed to originalism, the rights that are then in jeopardy. I think of so many rights throughout the Constitution that can't be justified from an originalist perspective. And a court that's originalist, and a court that has no regard for precedent, is, I think, truly dangerous for all of our rights. So I think, unless there's other opening comments, why don't we start looking at cases? And Amanda, I think you were going to start with Bruin?
So Bruin is the Second Amendment case the court decided. And in some respects, it's not that big of a deal, but in other respects, it's a very big deal. So it's not that big of a deal in the sense that you could have predicted how the court was going to come out, given the current court makeup, given the background of Heller. The case involved a 100-year-old New York law that required a showing of special cause for a permit to be issued to have a concealed weapon in public. And the court held, I think very unsurprisingly, that this law violates the Second Amendment. Unsurprisingly, I say, as a predictive matter. The plaintiffs in the case wanted the permits for self-defense and argued they should be allowed and that their Second Amendment rights were being unconstitutionally limited. The only question really then is what the standard of review would be for Second Amendment cases. And that's where the court's holding is really quite significant. We have a 6-3 decision, and Justice Thomas wrote for the majority in the case, and he held and wrote for the court that the right to carry a firearm in public for self-defense is a right that is deeply rooted in history. And he says, since no other constitutional right requires a showing of special need in order to exercise it, there's no such showing that should be required in the Second Amendment context either. And he went on to say individual self-defense is actually the central component of the Second Amendment right at issue. Now, this is meaningful because in the wake of Heller and McDonald, the other major Second Amendment case in its wake to really expand the scope of Heller, the Court of Appeals had developed a 2-step framework for analyzing Second Amendment challenges. And that framework looked to history, perhaps understanding the approach of Heller and the direction of this court, as Erwin highlighted, as Seth also did as well, this devotion to history. But the Court of Appeals tests also did means-end scrutiny, so they would do some balancing as part of their test. And the Supreme Court in the Bruin case said that this 2-part approach has one step too many. In other words, only the first step matters. We look to history and tradition to see how the law under review stacks up against historical laws. And that means that the court is throwing out any kind of means-end scrutiny, any kind of balancing, and focusing instead entirely on constitutional text and historical practice. And so the court says this is more faithful to the original meaning, this is more akin to strict scrutiny. The tests that the Court of Appeals were using, courts of appeals was using, was really akin to intermediate scrutiny, and that's not enough to protect the Second Amendment right. So if we're going to look at history and tradition, the court says, we'll acknowledge, Justice Thomas says, that history can be difficult and nuanced. Query how much the court really does acknowledge this, because then he goes on to say, nonetheless, reliance on history to inform the meaning of constitutional text is more legitimate and more administrable than asking judges, quote, to make difficult empirical judgments about the costs and benefits of firearms restrictions, especially given their lack of expertise in the field. So instead, the test that results is one that says, to justify a regulation, the government may not simply posit that the regulation promotes an important interest. Rather, the government must demonstrate that the regulation is consistent with the historical tradition of firearm regulation in this country, and only if a firearm regulation is consistent with that historical tradition may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. In other words, the meaning is fixed at the time of ratification. No balancing. Government interest is irrelevant. This is very, very strict scrutiny. I think Erwin, has called it even stricter than strict scrutiny. So I don't know, is that strict scrutiny on steroids? I don't know what we call it. Stricter scrutiny. The majority opinion does suggest that it would uphold laws banning guns in sensitive places because there is a history of that kind of regulation. And so that might be quite significant. And indeed, Justice Kavanaugh wrote a concurrence in which the Chief joined, and he said in his concurrence that this goes to your point about the Kavanaugh court, many of the state restrictions that are on the books are likely still permissible, including, he reemphasizes, bans on weapons in sensitive places and bans on especially dangerous weapons. So this is obviously very important to legislators in terms of thinking how to react to the case. A final note about the majority opinion by Clarence Thomas. He cites Yes, I am not misreading this. He cites Dred Scott favorably in the opinion, which is truly extraordinary. Breyer writes a dissent that opens with the following sentence. In 2020, 45,222 Americans were killed by firearms. And he went on from there. He referenced Uvalde. He referenced just really pages and pages of statistics on the horror guns are waging in this country. He also reads the history very, very differently, importantly. And he finds many examples, particularly during the Reconstruction period, which is relevant because we're talking about New York, and the Second Amendment only applies to New York regulations through the 14th Amendment. And he shows lots of examples, lists lots of examples on regulation and or bans on concealed weapons. This provokes a response from Justice Alito, which I think is one of the most unprofessional opinions I think I've read from a justice. He says the decision is narrow. I don't know what all the fuss is about. This decision is anything but narrow, let's be clear. And then he particularly goes after Breyer and says it's out of bounds for Breyer to highlight gun violence in this country. I just don't see the point of this opinion. You won. Why write this concurrence? And I think the concurrence revealed, and this is why I label it as unprofessional, as I said, it reveals that the relationship among the justices is completely imploded. And I think that is not something that should be aired for public consumption. It's not good for the court. It didn't accomplish anything significant or substantive, so I don't understand why the opinion was written. I think this is a case that highlights very well how history is messy, far, far more messy than the majority opinion acknowledges. So it is an important window into how originalism works and some of its failings. But I do think it's worth emphasizing that the opinion, even the majority opinion, does not rule out that, for example, high-volume magazines and weapons of war could be prohibited. As Kavanaugh says, there can still be regulations in sensitive places. And so at the end of the day, the real question to me is, why aren't legislators doing something within the sphere where they have been given license to regulate? And so this is a case that is not just a case that tells a story about the Supreme Court. I think it highlights some of the other things that are not working in this country.
Thank you, Seth.
So one way to think about the issue in Oklahoma versus Castro Huerta, the case I'm going to talk about, is to ask yourself a question with me. Would the people of California have an objection if the state of Texas tried to enforce Texas's criminal laws within California? I think the answer is yes, at least in this room. This is the question that Justice Gorsuch, writing in dissent, posed to Justice Kavanaugh, who wrote the majority opinion in Castro Huerta. To ask the question, of course, is to answer it. It's also to identify that Castro Huerta is a case about sovereignty, but it's not a case that pitted two states against one another. Instead, the state of Oklahoma was facing off against a criminal defendant who argued that the state did not have jurisdiction to prosecute him for child neglect. His argument was that the crime occurred in Indian country. Now, Indian country is, among other things, a legal term under federal law. It includes reservations of native nations, and its definition is important for, among other things, the allocation of criminal jurisdiction. Castro Huerta argued that states are largely excluded from prosecuting crimes in Indian country out of recognition of the sovereignty of native nations. So at its core, the case pitted native nations against the state of Oklahoma. Now, the backdrop to the court's opinion in Castro Huerta is the court's opinion in McGirt versus Oklahoma. And in that case, the court held that the reservation of the Muskogee Creek Nation, which included parts of eastern Oklahoma, was Indian country. Almost immediately, the state of Oklahoma decided to attack the court's decision in McGirt, even calling for it to be overruled in its petition for certiorari in Castro Huerta. Reading McGirt and Castro Huerta together is a good way to get whiplash. Justice Kavanaugh's opinion did not try to hide his frustration with McGirt, which was decided just 2 years ago when Justice Ginsburg was still on the court. But Castro Huerta does not overrule McGirt. It is still the case that states do not have jurisdiction to prosecute Indians for crimes in Indian country unless Congress has clearly authorized it. It's still the case that Native nations are recognized as sovereigns under federal law, and in fact, last term, the court reaffirmed just that in Dinespe versus United States, another federal Indian law case. So the question in Castro Huerta then boils down to whether the state of Oklahoma could prosecute non-Indians for crimes committed against Indians in Oklahoma's Indian country. Prior to the court's decision, the rule was clear. Oklahoma did not have jurisdiction because Congress had not clearly authorized it. What Castro Huerta does is flip the rule. It held that a state may prosecute non-Indian on Indian crime within Indian country unless the state's authority has been preempted. In reversing this rule, the court didn't try to make sense. It didn't even try to make sense of centuries of jurisprudence and historical practice that established some fundamental principles of federal Indian law. One of those principles, stretching back to the founding, and I could cite to you George Washington, Henry Knox, the first Congress, the Supreme Court, is that states are largely excluded from Indian affairs. Justice Kavanaugh acknowledged that that was the original understanding. And then he said, the original understanding doesn't matter. Why not? Well, because in 1962, in a stray statement, the Supreme Court said something along the lines of, the original understanding has been backed away from. 1962 is important. Why? That is in the middle of a short-lived period of federal Indian policy called the Termination Era. Why was it called that ominous name? Because Congress was terminating its recognition of the governments of various Native nations, including many in California, and the legacy of that continues to this day, including here in the East Bay. So I don't know about you, but I'm not sure that I would want to be hanging my hat on an opinion from the Termination Era. I would note Richard Nixon, when he was president, said, let's stop this policy. Richard Nixon said that. And Congress responded by stopping the policy and adopting the tribal self-determination policy, which has continued to this day. So even though Castro Huerta is inconsistent with Congress's current tribal self-determination policy, it actually does reaffirm some things that I want to highlight. It reaffirms that tribal sovereignty of its own force can preempt state jurisdiction in Indian country. The court says there's two ways that state jurisdiction can be preempted: by a federal law, like a treaty or a statute, or by tribal self-government operating of its own force. The court in this case says neither one of those preempted Oklahoma's jurisdiction. It really stressed policy considerations, the court did. It said more law enforcement in Indian country is going to be a good thing. Which brings us back to Justice Gorsuch's question. If more sets of prosecutors are always better, why not allow Texas to prosecute crimes in California? So I'm going to end with one more word about Texas. Last term, the court also decided the Isleta del Sur Pueblo case, which involved a jurisdictional battle between the Pueblo and Texas. And the Pueblo, this may surprise you, won. Justice Gorsuch wrote the majority opinion, which reaffirmed two principles of federal Indian law. First, Native nations have inherent sovereignty that is recognized under federal law. Second, it's the job of Congress, not the courts, to authorize any state encroachment on tribal lands. So I wouldn't be shocked, actually, if the principles in Isleta Pueblo survive longer than anything that's in Castro Huerta. Federal Indian law has more than a few seeming bombshells that turned out to be duds. Congress has responded before when the court has departed radically from fundamental principles of the field, and Congress may do so again here.
Thank you. We're talking about major cases in last term, so we have to talk about Dobbs versus Jackson's Women's Health. It follows a Mississippi law that prohibits abortion after the 15th week of pregnancy. In 1973, in Roe versus Wade, the Supreme Court held that states cannot prohibit abortions prior to viability. In Planned Parenthood versus Casey in 1992, the court said it was, quote, reaffirming the essential holding of Roe that states could not prohibit abortions prior to viability. Science and medicine tell us that viability now is about the 23rd or 24th week of pregnancy. What's often forgotten is that Roe and Casey were bipartisan decisions. Roe was a 7-2 ruling. The majority opinion was written by Justice Harry Blackmun, who had appointed the court by Republican President Richard Nixon. Also in the majority were Chief Justice Warren Burger and Justice Lewis Powell, who had appointed President Nixon. The two dissenters were Byron White, who had been appointed by President Kennedy, and William Rehnquist by President Nixon. Even more stunning, in Planned Parenthood versus Casey, it was 5-4 to reaffirm Roe, and all 5 in the majority had been appointed by Republican presidents. Justice Blackmun by President Nixon, Justice Stevens by President Ford, Justice O'Connor and Kennedy by President Reagan, Justice Souter by the first President Bush. In Dobbs, Justice Alito wrote the opinion for the court overruling Roe. He was joined by Justices Thomas, Gorsuch, Kavanaugh, and Barrett. He said, quote, that Roe was egregiously wrong and, quote, exceedingly poorly reasoned. He said a right should be protected under the Constitution only if it's stated in the text or part of its original meaning or there's long unbroken tradition. He said abortion doesn't fit into any of these categories. He said stare decisis doesn't need to be followed when a precedent is so clearly wrong. He said government regulations of abortion should be upheld so long as they meet the rational basis test. They're rationally related to legitimate government purpose. I can count on less than the fingers of one hand the instance in which the Supreme Court has found anything to violate the rational basis test since 1937. Chief Justice Roberts concurred in the judgment. He said he would uphold the Mississippi law, allow states to prohibit abortions after the 15th week of pregnancy, but not reach the question of whether to overrule Roe. Justices Breyer, Sotomayor, and Kagan wrote a joint opinion that was predictably vehement. They defended Roe in its reasoning. They stressed stare decisis. They emphasized the effects on women's lives. What's this decision going to mean? Well, for now, it means that the issue of abortion is left to the states. It's estimated that over half the states will prohibit all or virtually all abortions. Alabama and Oklahoma, for example, prohibit all abortions from the moment of conception, with only an exception to protect the life of the woman. It's estimated that slightly less than half the states will continue to protect abortion rights. California has found that its constitution protects the right to abortion. Just this week, California Governor Gavin Newsom passed laws strengthening the right to abortion here in California. The practical effect of this, as the dissent pointed out, that in states where abortion is illegal, women who want abortions, who have the resources, will travel to places where abortion is allowed. Before New York became the first state in this country to legalize abortion in the 1960s, 25% of the abortions in England were performed on American women. It wasn't poor women who were going to England for abortions. The dissent said, for women who are economically disadvantaged, for teenagers, it'll again be the choice to an unwanted child and an unsafe back alley abortion. I expect we are going to see a flurry of legislation across the country in response to this. There's bills pending in state legislatures that would make it a crime for a woman to cross state lines for abortion. Some states already have laws that prohibit importing into the state medication that would induce an abortion. There are proposals in some states to outlaw methods of contraception, like the morning after pill and the IUD, that are thought to take effect after conception. There are bills pending in some places that would regulate in vitro fertilization, requiring all embryos be implanted once fertilized, which may make the practice unworkable and impractical. Now, I intentionally chose the phrase, "for now, this is left to the states." Congress could adopt a law nationally creating a right to abortion or prohibiting all abortions, preempting state laws. A bill passed the House this past spring that would have created a national right to abortion, but it died in the Senate because of a filibuster. Just 2 weeks ago, Senator Lindsey Graham introduced a bill that would prohibit all abortions after the 15th week of pregnancy, preempting laws like California's. I predict that the next time there's a Republican president, Republican Congress, such a bill will be adopted. There's going to be a tremendous amount of litigation. Does there have to be an exception for protecting the life of the woman? If so, how is that to be determined? Does there have to be an exception for the health of the woman? How is that to be determined? What about a federal law that requires hospitals to provide necessary medical care to pregnant women? And sometimes that includes abortions, like this ectopic pregnancy or a miscarriage. Does that then preempt contrary state laws? What about the threat of some states to criminalize those who assist a woman traveling across state lines to get an abortion? And so on. And what about other constitutional rights that are protected under the liberty of the Due Process Clause? Justice Thomas, in a concurring opinion in Dobbs, said, now the court should overrule Griswold versus Connecticut, the 1965 case that protected the right to purchase and use contraceptives, Lawrence versus Texas, the 2003 decision that said the states cannot criminally prohibit private, consensual, adult, same-sex sexual activity, Obergefell versus Hodges, the 2015 case that said states cannot outlaw same-sex marriage. Justice Alito, in his majority opinion, said none of those rights are in jeopardy because they don't involve, quote, potential life. But none of those rights meet the criteria that he articulated. None are in the text of the Constitution. None were part of the original meaning. For none is there a long, unbroken tradition. In fact, Justice Alito, along with Chief Justice Roberts and Justice Thomas, vehemently dissented in Obergefell. So it's hard to take the reassurance from Justice Alito here is providing much comfort.
On that happy note, I want to do just a little bit of a recap of some of the criminal justice issues that came before the court last term. None of which are probably my sort of like number one pick for most important case in their own right, but each of which encapsulates some of the themes that we've been talking about. So the first case I want to discuss is a case that Professor Tyler alluded to. It's a case called Brown versus Davenport. So this is a habeas case, right? It's about when can federal courts vacate convictions that were obtained in state court. Justice Gorsuch a few terms ago wrote in a concurrence for himself his philosophy around habeas. He basically says, look, until this case called Brown versus Allen, federal courts basically never did this. They basically did this if the state court didn't have jurisdiction, whatever that means, and in no other circumstances. The Supreme Court's decision in Brown versus Allen dramatically expanded that. And then what he says next is a little bit interesting. So he doesn't just call on the court and say, like, we're going to overrule Brown versus Allen tomorrow. What he says is, from here on out, I am going to vote as though Brown versus Allen is not on the books. So this is sort of a fascinating new development, right? This sort of idea that it's not just about the cases that the Supreme Court's overturning, but this idea that they're going to sort of, even the cases where they feel like they don't want the press or the hassle of overturning them, they're going to vote as though they're not in the books. And indeed, what you see this term is, in this case, Brown versus Davenport, and the details don't matter for our purposes, Justice Gorsuch gets a majority of the court to sign on to effectively this methodology. And you see this in a variety of settings. So another case in this past term that's called Cummings, it's nominally about what kinds of damages are available in sort of private right of action cases. And you see some concurrences that say, we really don't, the cases that said you can imply a private right of action under a federal statute, so basically if a federal statute doesn't explicitly say that private citizens can sue in court, the Supreme Court has developed a test that says, sometimes they can do so anyway. He says, the cases sort of saying that, I don't really think those are good law anyway. I'm not saying we should overturn those, but let's vote as though those weren't on the books, right? You see, there's another case called Egbert, which is about what are called Bivens claims, this idea that you can sue federal officers. There's no federal statute authorizing that, but the Supreme Court has long held that in certain cases you can sue federal officers for violations of the Constitution nonetheless. Supreme Court again says, well, we're not getting rid of Bivens. It's still on the books. In fact, they turned down a request to overrule Bivens, right? So this case presents one of the questions is a sort of question about whether these particular claims can be brought as Bivens actions. There's also a second question about Bivens more broadly. And the Supreme Court declines to consider that second question. We're not going to talk about overruling Bivens. But then in their opinion basically says, Bivens was kind of a ticket good for one right only. Like that's going to stay on the books. But we're gonna pretend it's not there when we analyze future cases. And I think this is in some ways almost more damaging than the straightforward overruling of precedent the Supreme Court does, because at least when the Supreme Court owns up and says we're overruling Roe versus Wade, the political process can take account of that and the appropriate backlash can occur. The other branches can act. When the Supreme Court does this, what I should call, is anyone going to get a reference to Sliding Doors, the Gwyneth Paltrow movie? I call the sort of sliding doors approach to precedent, which is like, let's pretend we're in an alternate universe where this precedent doesn't exist. They don't get to, there's no sort of accountability for that because it happens in such a sneaky way. And it's really damaging for the rule of law, because if the Supreme Court is making decisions that are good for one right only, that don't establish a broader principle, it's hard to know how lawyers make arguments to the court, right? So that's the first case I wanted to highlight, is this habeas case. The second case I wanted to highlight is a case called Ramirez versus Collier. And I think of this case as sort of answering the question, does the Supreme Court care more about religious liberty than about speeding up executions, or vice versa? And it turns out for 8 justices of the Supreme Court, when these two strongly held values clash, they pick religion. So this is a case where the state of Texas has very strict protocols about the spiritual advisor who can be in the chamber at the moment of execution. And because of those rules, a spiritual advisor, a prisoner who is being executed, can't have his chosen spiritual advisor lay hands on him or pray audibly, both of which are really important to his faith. And the Supreme Court says in an 8-1 decision, under a statute called the Religious Land Use and Institutionalized Persons Act, this is a significant burden on his religion, and there's not a sufficient justification for doing it. What's fascinating about this case, though, is a lot of the things that the state had said, things like we're not going to be able to find, this is a very delicate procedure, there's these dramatic security concerns, those sorts of things that states have said that have carried the day in, for instance, challenges to methods of execution as unconstitutionally cruel. There's one case where an expert testified that this method of execution might feel like being burned alive. And in those cases, the Supreme Court has always said, security, this is a delicate procedure, security of the chamber, that trumps everything. And yet in this case, where the other side of the equation is religious liberty, the Supreme Court is suddenly more solicitous. And then the final thing I just want to sort of flag is Professor Tyler alluded to this so-called shadow docket. These are the cases that every year the Supreme Court decides without briefing an argument. They think that the lower court decision is so obviously wrong that they can do so. For many years, including when I was clerking, there was sort of a special place on that docket reserved for summary reversals of denials of qualified immunity. So it's cases where a state officer, usually a police officer, was going to be forced to stand trial for something that they did, usually for using excessive force in violation of the Fourth Amendment. And the Supreme Court routinely, every year, between 2 and 4 cases where a lower court had the audacity to say a police officer needs to stand trial, the Supreme Court would reach in, summarily reverse, not even ask for briefing or oral argument, just say, you got it wrong, there's no way this officer should stand trial. Then the Supreme Court took a 3-year hiatus from doing so. For 3 consecutive terms, they did none of these. I think it's sort of no coincidence, the timing of that. And I'm here to sort of share the bad news that that hiatus appears to be over. So the Supreme Court opened the last term by, again, in 2 different cases where police officers had used excessive force to brutalize people, where no one was really disputing even that the Constitution was violated. The Supreme Court nonetheless said, because of this doctrine called qualified immunity, these police officers don't have to stand trial. So those are sort of my criminal justice recaps. I wanted to make sure that we talked about a couple of those cases, even though they're not necessarily the ones making the headlines.
Thank you. As I mentioned, and as you know, Monday is the first Monday in October. The justices come back for the first time since 1994. Stephen Breyer won't be on the bench. For the first time, there'll be a black woman on the bench, Justice Ketanji Brown Jackson. I'd ask each of my colleagues to pick one case to talk about, and if we could each confine our remarks to under 5 minutes, so then we can have the rest of the time for questions. Seth, do you want to start?
Happy to, Erwin. Thank you. So I'm going to talk about Health and Hospital Corporation of Marion County versus Talevsky, and I'll be brief and happy to flesh out during Q&A. It's a case that's about the enforcement of federal rights that are contained within spending clause statutes. Spending clause statutes are statutes enacted when Congress is using the power of its purse to say to state actors or private actors, you can have this pot of money if you comply with certain conditions. Sometimes those conditions are you have to respect these important federal rights that we are recognizing in this spending clause statute. Now, under existing law, private parties can use 42 U.S.C. 1983 to enforce federal rights in spending clause statutes. In Talevsky, the petitioners are challenging that principle. They are saying in particular that in 1990, in a case called Wilder, where the court confirmed that you can use Section 1983 to enforce rights in spending clause statute, the court got it wrong. That the court got it wrong as a matter of the original understanding of Section 1983, that when Congress enacted Section 1983 in 1871, it did so against the backdrop of the common law of contracts, and at least according to the petitioners, although my colleagues Erwin Chemerinsky and Melvin Eisenberg respectfully disagree, but at least in the view of the petitioners, the common law of contracts in the 1870s would not have allowed a third-party beneficiary to sue to enforce a contract. So the idea is if one of us has a right under a spending clause statute that's entered into between, say, a local government and the state on the one hand and the federal government on the other, we're a third-party beneficiary of that. We don't have a right of action under 1983 to enforce our rights under that statute. So this is an important issue, whether Section 1983 is going to remain available to provide a cause of action for rights in spending clause statutes, because there are many important federal rights that are contained within spending clause statutes. The federal government can't enforce all of them on its own. And moreover, 1983 is an important vehicle for enforcing private rights because, among other things, Congress has created a fee-shifting mechanism to encourage Section 1983 suits. Part of what's going on in this case is that the petitioners are trying to pick up on this trend that Easha described of the court cutting back on private enforcement of federal law. But notice, while the cases you talked about involve implying private rights of action from, say, statutes or the Constitution where there is no congressional action to create an express right of action, Section 1983 isn't an express right of action, but the court has been tightening up on its availability. I think, for instance, of a 2002 decision that I'm happy to discuss. Of course, on the other side, Talevsky argues, look, the court didn't get it wrong in Wilder. This is a principle that was implicit in many of the court's decisions prior to Wilder. Section 1983 on its face secures rights under all federal laws, and that would include spending clause statutes. Moreover, the common law of contracts doesn't control, Talevsky argues, and even if it did, Irwin and Melvin are right, and it supports the idea that there would be a cause of action here. I'll just conclude by saying the U.S., appearing as amici in support of neither party, has tried to give the court a narrow way to rule against Talevsky. That narrow way would basically say, look, 90% of nursing homes are run by private actors. So when Congress created the rights that are at issue in this case, and they're rights that patients in nursing homes have as against the nursing home, it probably wasn't thinking about Section 1983 suits against local governments running nursing homes. And moreover, Congress created some administrative enforcement mechanisms. So we should basically say, the SG argues, that Congress implicitly precluded Section 1983 relief based upon what I just said. We'll see if the court takes the SG's, the Solicitor General's invitation to rule on narrow grounds. You know, as we've talked about, stare decisis isn't what it once was, and we'll see what it is in the Talevsky case.
Thank you. We've all mentioned stare decisis and the court giving very little weight to precedent. I think we're going to see the importance of this in two cases that are going to be argued on October 31st. Students for fair admission versus University of North Carolina, and students for fair admission versus Harvard College. In 1978, in Regents University of California versus Bakke, 5 justices agreed that college universities have a compelling interest in a diverse student body, and that college universities may use race as one factor in admissions decisions to enhance diversity and benefit minorities. In 2003, in Grutter versus Bollinger, Justice Sandra O'Connor wrote for the majority in a 5-4 decision, and again said that college universities have a compelling interest in a diverse student body, and college universities may use race as one factor in admissions decisions. In 2016, in Fisher versus Texas Austin, the Supreme Court again reaffirmed this. Students for fair admission versus University of North Carolina involve the University of North Carolina doing exactly this. Students for fair admission versus Harvard involves Harvard College doing this for its undergraduate population. Why are both cases before the Supreme Court? Well, as you know, the Constitution and equal protection apply only to the government. That's the University of North Carolina case. But Title VI of the 1964 Civil Rights Act says that recipients of federal funds cannot discriminate on the basis of race, and that's the Harvard College case. So the issue here is about whether all colleges in the United States, public and private, are going to be prohibited from engaging in affirmative action. I don't think that there's much doubt in anyone's mind, liberal or conservative, as to what the Supreme Court's going to do in these cases. Chief Justice Roberts has made clear from coming onto the court that a key part of his agenda is eliminating affirmative action. In 2007, in Parents Involved in Community Schools versus Seattle School District No. 1, Chief Justice Roberts said the Constitution requires that government be colorblind. He said there the way to stop discrimination based on race is stop discriminating based on race. He, along with Justice Thomas and Alito, dissented in Fisher. Now, of the justices who were in the majority in Fisher, Justices Kennedy and Ginsburg are no longer on the court. I can't count to 5 justices who would today reaffirm Bakke and Grutter and Fisher. I think the end of affirmative action in the United States is going to have a devastating effect on diversity in college universities. We've seen that here in California. In 1996, Proposition 209 was adopted that said that there can't be discrimination or preferences in education, contract, or employment on the grounds of race or sex. Take UCLA as an example. It took over 20 years after 1996 for UCLA to get back to its pre-1996 levels of diversity. Or as some of you know, at this law school, after 209, there was only 1 black student in the class, and that was somebody who had deferred admission. Now, I think that California and states like Michigan and Washington State with similar initiatives are going to need to play a key role in helping college universities throughout the country. We have all found ways to achieve diversity without being able to engage in affirmative action. But it took a long time to come up with them. It took an enormous will and effort. And I worry that in some places that will and effort won't be there. So when we talk about cases, they're going to have a real effect on people's lives and on institutions across the country. These cases that will be argued on October 31st certainly meet that standard.
So I want to just flag a case, and we'll do no more than flag it because it's an enormously complex case with a lot going on that I think folks should be paying attention to, and that raises some of the same questions and themes as the cases that Dean Chemerinsky was just talking about. So this is a case called Burkeen versus Halen. It's a challenge to the Indian Child Welfare Act. And in the interest of disclosure, the clinic that I teach at Stanford was involved in representing the Navajo Nation, and Professor Davis also filed an amicus brief in this case. And if we have some time during the open session, I'd be curious to hear Professor Davis's thoughts because he's such an expert. So the Indian Child Welfare Act was passed in response to a real crisis among Native communities. At the time it was passed, between 25 and 35% of all Indian children had been separated from their families. And an alarmingly high percentage of those were placed in non-Indian foster and adoptive homes. Now, some of that was because of federal policies like boarding schools, but a remarkably high percentage of it was happening through state custody proceedings. This was sort of an existential threat to tribal self-governance, right? Without being able to pass down traditions to a subsequent generation, without having folks growing up in this in the sovereign, the tribes were on the verge of being decimated. So the Indian Child Welfare Act was designed to combat that problem, and it imposes strict requirements both on the removal process and then requirements on the placement process that results in a sort of preference for placement into homes that will allow the child to continue to grow up within the auspices of the tribe. In this litigation, both state and individual plaintiffs are challenging the law on 4 separate grounds. The first is Congress does not have the power to pass a statute like this. There's no enumerated power giving them the ability to do that. The second is sort of what's called anti-commandeering. So this idea that you cannot enlist the state apparatuses of government for federal purposes. The third is under the Equal Protection Clause. So the idea that this is the preference for placement with Indian families is a racial classification that's subject to strict scrutiny. And the fourth is this idea of sort of what they call non-delegation. So there's an ability within the law for tribes themselves to displace some of the infrastructure of the law, and this is what they call a non-delegation problem. I suppose that there's a lot to say about the case. Maybe one point I'll just sort of leave you with is I'm watching this case primarily to see which Chief Justice Roberts shows up. So that is to say, there's the Chief Justice Roberts that Dean Chemerinsky talked about, who's made it, since his time in the Reagan Department of Justice, a mission to get rid of what he perceives as racial classifications, who talks and parents involved about, the way to stop discriminating on the basis of race is to stop discriminating on the basis of race. Then there's a Chief Justice who seems to understand that tribal classifications are something fundamentally different. And one clue to that is that when the Chief Justice was in private practice, he represented Governor Cayetano of Hawaii in a case about whether a Hawaii law, which allowed kind of trustees of a state agency to be elected solely by particular categories of Hawaiians who could trace their ancestry back to the inhabitants of Hawaii in the 18th century. He represented the governor of the state of Hawaii in a Supreme Court case about whether or not that was a racial classification and argued that it wasn't. So again, so much more to say about this case, but I just wanted to put it on folks' radars as another kind of important blockbuster case, and one that could have tremendous upheaval depending on how it's decided for dozens, hundreds of other incredibly important statutes that Congress has passed to regulate their relationships with tribes.
All right. I'll try to be brief because I know you all have many questions. This is a big term. We're only talking about a few of the cases. There's a gay wedding case involving First Amendment issues called 303 Creative. There are a bunch of big cases. One of them, one of 2 huge Voting Rights Act cases, or voting cases, I should say, is a case called Moore versus Harper, which is out of North Carolina. In that case, the Speaker of the North Carolina House of Representatives asked the Supreme Court to consider the so-called independent state legislature doctrine. or theory, I should say. And the theory posits that the Constitution gives state legislatures alone the power to regulate federal elections in their states without the oversight of state courts. So where does the argument come from? It comes from the Constitution's text, and specifically its Elections Clause, which states that the time, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. And the argument goes, it follows from that all regulation of such elections can only be done by state legislatures. Unlike other constitutional provisions, the argument is the clause does not refer to the state itself, but specifically to state legislatures. Now, why does this matter? It matters because the North Carolina Supreme Court had held that the map in question was an unconstitutional partisan gerrymander. Emergency relief in this case was denied over three dissenting votes by Alito, Thomas, and Gorsuch. Kavanaugh said the court should grant cert. It did, and there is a record showing that all four of them are very interested in this theory. Now, why does this matter? This matters because of a case called Rucho versus Common Cause decided by the court in 2019. In that case, writing for the court, Chief Justice Roberts held that political challenges to partisan gerrymandering present political questions, and the federal courts cannot hear such challenges as a result. That opinion's all over the place. We don't have time to talk about it. The bottom line, though, is that leaves any limitations on partisan gerrymandering really to be handled at the state level. What is fascinating to me is that in the Rucho opinion, at the end of the opinion, Chief Justice Roberts specifically predicts and invites state courts to get involved in these cases. And indeed, in many states, under state constitutional law, the state courts are checking partisan gerrymandering. If the theory of the independent state legislature prevails in Moore versus Harper, there will no longer be the ability to challenge partisan gerrymanders in either federal or state court. And the effects of that, it would be hard to overstate just how dramatic they will be and how much more political entrenchment we will see follow. It is a truly massive case because it really does go to voting rights in the most basic, most elemental sense.
We are exactly on schedule. I want to thank my fellow panelists. We said we're going to leave 15 minutes for questions, and we're exactly at the 15-minute mark. So questions about anything you want to ask any of us about the Supreme Court and where it is now, where it's likely to go? I see a hand on the aisle there. Just speak up so we can all hear you, please. Was there a microphone? Oh, they bring you a microphone.
I think sorry. Maybe we can call on Rookie next for her question.
This is always weird, but hi, my name is Marcella, class 097. You started the panel by saying that we are close to a point of the court losing legitimacy, but aren't we there already by the two tokens, the two measures of your average person thinks it's a very politicized body. And then I read Costa Huerta, Dobbs. The first thing that the Supreme Court is going to be hearing on Monday is Sackett, a Clean Water Act case to get rid of significant nexus, a recent precedent in Rapanos. So my question is, aren't we more at the point, even if Congress passed a right to abortion or a right against or law against abortion, it would end up in the same Supreme Court and the same result. Isn't it time to enlarge the court? Like, if we're going to save democracy, isn't it realistic to just disregard precedent in that sense and add more judges?
Somebody here want to talk about it? Everyone's looking at me.
Yeah, we want to hear
Everyone's
what
looking
Owen
at me.
thinks.
Let me start with the conclusion and then briefly address it. It's not going to happen. The reason is that it would take a statute to change the size of the Supreme Court, and Republicans would filibuster it even if Democrats wanted to make it happen. And there's no indication that the Democrats are willing to change the rules of the filibuster, especially for this. The size of the Supreme Court, as you know, is set by statute, not the Constitution. It's varied between 5 and 10 over the course of American history. 9 is a historic accident that's been there since 1869. President Franklin Roosevelt proposed expanding the size of the Supreme Court after the 1936 election. It turned out to be unnecessary when Justice Owen Roberts changed his mind and voted to uphold laws that previously would have voted to strike down. I personally would favor an expansion of the size of the Supreme Court for the reasons that you say, that I think that Republicans engaged in court packing and the way in which they blocked Merrick Garland from being confirmed, and the way in which they hypocritically rushed through Amy Coney Barrett. I would favor court packing because the reality is, unless there's an increase in the size of the Supreme Court, it is going to be a very conservative Supreme Court for a long time to come. Clarence Thomas is 74, Samuel Alito is 72, John Roberts is 67, Justices Gorsuch, Kavanaugh, and Barrett are all in their 50s. I've long thought that the best predictor of a long lifespan is being confirmed for a seat on the Supreme Court. Justice Stevens didn't retire until he was 90. Justice Barrett was 48 when she was confirmed 2 years ago. If she stays on the court until she's 87, the age Justice Ginsburg died, she'll be a justice through 2059. I recognize that the argument against expanding the size of the Supreme Court is if the Democrats do it, the next time there's a Republican president and Republican Congress, they'll do it too. But I think that's a risk that should be taken. But as I said, I don't think it's going to happen. Well, let the microphone, there's somebody right in the front row.
Thank you. Thank you so much.
Okay, thanks.
So, hi, my name is Rookie Tajani, and I just wanted to start off by just saying thank you so much for just such a fascinating panel on not just what's happened yesteryear, but what's soon to happen. Not only, it's giving Handmaid's Tale, really, but you know, but here we are, and this is why we have these discussions. But one of the things, and I don't know if it sounds kind of just like precocious or rudimentary, but one of the things that I've just always wondered in law school and beyond was even the concept of originalism one that would have been appreciated by the founders. And the reason why I say that, and hopefully people get this this analog in essence. So my faith is Christianity, and I am not a traditional Christian in a lot of senses. I believe in the right to abortion. I believe in the right to same-sex marriage. And I've always been hit with, well, God is the same yesterday, today, and forevermore. How many Christians have heard that? Like, God is the same yesterday, today, and forevermore, which may be true, but we're not the same as individuals. You know, at the time that many of the books in the Bible were written, women were seen as chattel. You know, homosexuality was actually seen as, to some extent, unconsented rape of young men. So I've always just wondered, is there evidence that originalism was at its core something that the founders would have been like, you know what, muskets, that's gonna be here today, tomorrow, and forevermore. So that's just always been something for me.
I'll say a word just to get us started. I think here, my colleague, Professor Tyler's reminder that history is messy is really important, because when historians look into, so first just taking your question as a historical question, right? When historians look into, essentially, would the founders have embraced originalism as a methodology, you can find evidence for both sides on that debate, right? Is the basic historical question. And I think history's messy, right? To the extent that we can find evidence on both sides, then we start to have to think about the normative case for or against originalism, which Erwin has spoken to a bit already. But I don't know if my colleagues have thoughts about this as well.
Boy, I think we should let Erwin tell everybody about his new book on originalism.
Thank you for the plug. I didn't ask Amanda to do that. The title of the book probably answers your question. The title of the book is Worse Than Nothing, The Dangerous Fallacy of Originalism. And in it, there is a chapter in which I address the question that you pose. I think there's a strong argument that those who wrote the Constitution did not think that there's going to be anything like originalism. Now let's start with the fact the Constitution doesn't mention judicial review. It's unclear whether or not the framers thought that there'd be the power to review the constitutionality of statutes and executive actions. But you also look at other evidence. The official notes of the Constitutional Convention were taken by James Madison, who instructed that they not be looked at until after his death. Right. Joseph Ellis wrote a terrific book that came out a few years ago, in which I think he makes a very strong argument that the framers did not intend originalism. Jeff Powell wrote an article in the Harvard Law Review in the mid-1980s called The Original Understanding of Original Understanding that makes the argument that originalism was not intended. Now, what Seth says is right. It's also hard to take our views with regard to interpretation and try to figure out what did they think about them. They believed in natural law in a way that seems unfathomable to us today, that justices and judges would go out and discover what the natural law was and apply it. But I also think there's a very strong argument that if one wanted to be an originalist, one would have to abandon originalism if they were going to follow the original intent with regard to constitutional interpretation. And thank you for the plug, Amanda.
As I tell Erwin, he keeps lapping me repeatedly. He writes so many darn books. He makes the rest of us look bad. But I guess actually at the end of the day, I'm okay with that because he's my colleague and I can brag about him.
A question over here, an administrative law question that's coming out of one of the circuit courts. There's a case called SEC versus Jarkissi, and among its holdings is that the Dodd-Frank Act violated the non-delegation clause by empowering the SEC to choose whether it would bring enforcement actions either in federal court or in its administrative form. And in doing so, they say that they've given an Article I power to an Article III body. But they also say that the Dodd-Frank Act doesn't provide any sort of discernible principle by which an administrative agency could enact the legislative intent. And the prediction that I would like to ask for is if this thing makes its way up to the Supreme Court, what can we expect in terms of the philosophy that's going to come out about how much reach administrative agencies are going to be given for legislative prescriptions, especially when given that many legislative prescriptions are very light and very messy because they are political compromises and they don't necessarily reflect the understanding of subject matter experts that would be otherwise expected to implement them.
So just very interesting set of questions. I think briefly for me it comes down to the question of how much is the court going to the court's majority going to constitutionalize its concerns about delegation of authority to agencies. I actually think there are reasons to believe that the majority is not going to constitutionalize it as much as we might otherwise suspect. Although I'm not sure. Take, for instance, the major questions doctrine case from last term, West Virginia versus EPA, a case that confirms a doctrine that basically says there are certain extraordinary circumstances and major questions where if Congress wants to authorize agencies to answer those questions, it must do so clearly. In a concurring opinion, Justice Gorsuch says, essentially, I think this is a clear statement rule that reflects underlying constitutional concerns about the breadth and depth of delegation to agencies. But it is not itself a reviving of the non-delegation doctrine, which has laid dormant for quite some time. And that's where I think I'll pause there or stop to hear my colleagues' thoughts.
I'm more uncertain than you are, I think, about that. Let me try and explain why. In 2019, the court decided a case called Gundy versus United States that involved delegation of power to the Attorney General under the Sex Offender Registration and Notification Act. The court 5-3 upheld the law and rejected the non-delegation argument. Justice Gorsuch wrote a vehement dissent, joined by Chief Justice Roberts and Justice Thomas, saying we need to revive the non-delegation doctrine and revive it now. Justice Alito was the fifth vote in the majority. He concurred in the judgment. And he said, if there was a majority today to revive or re-examine the non-delegation doctrine cases, I would join them, but we don't have such a majority today. And so I'll apply the laws that's existed since 1935. The last time the court struck something down is an excessive delegation of power. Justice Kavanaugh then was confirmed for the court. And at first I was puzzled by why didn't the court just grant re-argument? They did that in some other cases that term to allow Justice Kavanaugh to participate. And then I thought about it, and my speculation is this was about the Sex Offender Registration Notification Act in a year where there'd been such focus on whether Brett Kavanaugh engaged in sexual assault. This wasn't the case where they wanted to revive the non-delegation doctrine. Now, after the decision came down 5-3, the Gundy's lawyer asked the Supreme Court for rehearing, which is routinely denied in the court, but the Supreme Court kept relisting this, and then they denied rehearing with Justice Kavanaugh writing an opinion saying, I think Justice Gorsuch makes many important points that we're going to need to come back to. Well, you know that Gorsuch, Roberts, and Thomas want to revive the non-delegation doctrine. Alito seemed to indicate that. Kavanaugh seemed to indicate that. And I think Barrett is likely to be sympathetic with it. That seemed to create a majority. The difficulty is, if the court does that, how does it draw the line between what's a permissible and an impermissible delegation? And then, Seth, I think what you say is right. Maybe they'll use the major questions doctrine to get to the same place without reviving the non-delegation doctrine. With the major questions doctrine, they invalidate the agency action by saying that Congress hasn't given sufficiently specific delegation, but they don't declare the statute unconstitutional. But I come away from the Gundy case just being uncertain. I don't know, Amanda or Easha.
Since now we're all historians, I'm John Warner, class of 77. That's 19, not 1877. Since we're all historians, I'm wondering, when I reread the early cases, the John Marshall cases, McCulloch versus Maryland, and others, I get the clear impression that there was a lot of controversy over it. I mean, you look at the debate over the National Bank that's even part of the play Hamilton, and there was a very partisan divide in the country during, a good deal of the early days. My question is whether or not there have been other times when the Supreme Court, leaving aside the court packing in the New Deal era, when the Supreme Court has also been, its reputation being in disrepute. I mean, after the slaughterhouse cases, the whole, era until 1910. So just a question, any thought about that?
Yeah.
Too much already. They're calling
I
me.
want to hear what Dean Chemerinsky thinks.
No, there's no doubt that during the Lochner era, and especially the latter years of the Lochner era, the Supreme Court was suffering from the kinds of legitimacy crisis that we're talking about here. I mean, perhaps at the beginning of the Lochner in the 1890s, and when Lochner was decided in 1905, there was enough belief in a laissez-faire economy to support what the court was doing. We've got to remember also the court struck down the first child labor law in the United States in Hammer versus Dagenhart. By the time you get to the 1930s and the Supreme Court is striking down so many New Deal laws, given the tremendous economic crisis of the time, given the political popularity of Roosevelt, I think that was a crisis of legitimacy for the court, unlike any other that's been seen in American history. And I think that did lead Justice Owen Roberts to change his mind. But whether we'll see such a thing like that now, or whether it will lead to proposals like court packing being taken seriously, or whether there'll be other consequences, I don't think we can know at this moment in time.
How about
So we have time for one more question, is that right?
So when I listen to you and when I read West Virginia and EPA, it's like through the looking glass for me. But when you as con law professors go to conferences of con law professors and you talk to your more conservative colleagues who also, at least theoretically, are supposed to know the history and go through how do they justify? Do you ever discuss this with them? And how do they justify or handle what's going on, which seems to us so outrageous?
I mean, I will say to the credit of, to the partial credit of the position taken by the majority in West Virginia versus EPA, this is not the first time that the idea of a major questions doctrine had come up. Does it strengthen it? Yes. Does it harden it? Yes. Does it leave lower courts in the lurch with respect to guidance as to what they're supposed to do? Yes. Absolutely, all of that's right. I mean, I cited Gorsuch's concurring opinion because in my conversations with more conservative colleagues, and I co-blog with conservatives on notice and comment, which is an administrative law blog, right? They will. I cite Gorsuch's concurring opinion because they will point to a certain vision of the separation of powers and non-delegation, a constitutional bedrock upon which to place a clear statement rule. They will say this is common. We have federalism, clear statement rules, et cetera, et cetera, et cetera. So that is those are the doctrinal contours of the conversation. Is Irwin right that this is the product of in some ways, careful and very thoughtful and deliberate project of transforming administrative law? Yes. He and I might differ about where Justice Kavanaugh is likely to come down within the range of debate that exists in that project on that side of the political spectrum. But at least in my personal experience, that's some of the way the conversations go.
I fear we're out of time for this discussion. We'll come back at 3:30 and I'll give you a sense of the state of the law school. But would you please join me in thanking the other panelists for their wonderful presentation?